Today I'm going to talk about extradition laws, and I'm going to discuss also the Court of Appeal decision in Mr. Kanu's case. There seems to be some confusion at the moment as to whether the Court of Appeal discharged Mr. Kanu or acquitted him. But in order to understand what actually happened, that judgment and the effect of that judgment, is important that one goes to the basics of the law and the rule of law. My understanding is that the representatives of Mr. Kanu made an application by way of an appeal to the Court of Appeal to ask a legal question as to whether the High Court has any jurisdiction to try NNamdi Kanu on the remaining 7 counts. One has to recall that the counts were about 14 or 15 in number. In a previous hearing, the judge reduced the number of counts to 7. But what everyone has not understood, or what is not very clear, is that my understanding is that the people representing Mr. Kanu have not appealed to the Court of Appeal to decide the 7 charges that are remaining. Instead, my understanding is that the application that they made to the Court of Appeal was by way of an appeal, which was by way of judicial review, asking the Court of Appeal whether a Nigerian court has jurisdiction to try NNamdi Kanu, having been kidnapped, as alleged, from a foreign country and brought back into Nigeria. My understanding is that the Court of Appeal has answered that question by saying that the lower court has no jurisdiction and in effect has discharged Mr. Kanu. Now, the case falls back to the table of the government, who brought the charges in the first place. And there is an issue going on as to whether the Court of Appeal has discharged Mr. Kanu or acquitted him. Let me discuss discharge and acquittal. The way I understand the acquittal is that acquittal is what happens following a trial. The opposite of acquittal is conviction. The basics of the law is when a person is charged with a criminal offense, the person is arraigned before a tribunal with jurisdiction to try criminal offenses. And the person will take a plea, guilty or not guilty. If that person pleads not guilty, the matter will be adjourned for trial. It is only at the end of that trial can a question of acquittal or conviction come into play. None of these fall within the jurisdiction of Court of Appeal in this Mr. Kanu's case, because the Court of Appeal has no jurisdiction to try Mr. Kanu. However, the Court of Appeal has the power to review the decision of the court below. It is understood that those acting for Mr. Kanu did make an application to the judge that was the trial judge for Mr. Kanu's case. And the trial judge refused that application. And then the Kanu's team had to appeal to the Court of Appeal, stating that the trial judge was wrong not to rule that it has no jurisdiction to try the case, given that the government has not explained how Mr. Kanu, who was not in the country, now finds himself in Nigeria defending criminal charges. The truth of the matter is that whilst there is confusion as to what is discharge and what is acquittal, and whilst there might be problems as well with a Court of Appeal judgment, what we must face at the moment is the order as we have it, which states that the defendant, Mr. Kanu, is discharged. And the reason why I'm emphasizing on this is because the government have wrongly misinterpreted that judgment by saying that Mr. Kanu should not be released because the government did not state acquittal, and which is wrong, because the Court of Appeal did not state acquittal. Acquittal, as I said, can only come into play after a trial has taken place, which is not the case in Mr. Kanu's case. Because the opposite of acquittal is conviction. Now, the next one that I'm going to deal with is discharge. What is discharge? The Court of Appeal order states that Mr. Kanu is discharged. Basically, what the Court of Appeal intended to say was that the lower court or no Nigerian court has jurisdiction to try Mr. Kanu, given that there is no explanation as to how he was brought back to the country. My criticism of the Court of Appeal judgment is only on the order, not on the substance. What the Court of Appeal should have done was to stay the proceedings at the lower court, because the Court of Appeal has no jurisdiction to discharge complaints made before a lower court. The order that should have resulted from the Court of Appeal judgment, which was a correct one, would have been that proceedings against Mr. Kanu are suspended. If I should use the legal term, are stayed. Staying means halted. They are halted. But because the Court of Appeal did not say that, that is the reason why there is confusion. And it is further confused with the government saying that there has to be acquittal before they could release Mr. Kanu, and which is also wrong. Acquittal does not mean release somebody. A person can be acquitted following a trial, and that person can still be retried. Not for the same offense, but for possibly a similar or another offense. The government has the power to investigate crime, and they have the power of detention. It is within their power to hold a suspect. Like I said, What was missing in the Court of Appeal decision was that the Court of Appeal should have used the proper, in simple word, that Mr. Kanu should be released after ordering the discharge. Discharge in a legal sense means that the charges against Mr. Kanu are no longer on the court record. In the civil proceedings, the word that may be used would be struck out, or most people will say it has been thrown out. Civil jurisdiction and criminal jurisdiction are separate and similar in procedure. The effect of the outcome of both jurisdictions will be the same. That when a judge makes a decision in favor of a party, that party must enjoy the benefit of that decision. And where there is no benefit to enjoy, and where the person's circumstance has not changed after he has received a favorable decision, then one begins to question as to whether the judgment was correctly made or not. In civil proceedings, the benefit of a favorable judgment is that you receive money, or you are ordered not to pay money. In criminal proceedings, the benefit of a favorable judgment is that you're released from prison to regain your freedom. So, it is not reasonable, however, therefore, that the government, following the Court of Appeal judgment discharging Mr. Kanu, that Mr. Kanu should still be in detention. Practically, there is no reason why he should remain in detention, given the substance of the judgment that was made at the Court of Appeal. This now takes me through to explanation of extradition procedures. Extradition is the process of bringing someone from another country to requesting country to face trial or face imprisonment following a trial. And the process is daunting, which is the reason why governments would rather avoid it. If you make an application or a request to a country to extradite someone to your country, that country, which is the requested country, will send your request to their high court. The high court of that country will review that request and decide as to whether there is enough evidence to find the person guilty, or if the complaint against that person has any prospect of success in the requesting country. And if they find that there is a complaint against that person in that country that has good prospect with evidence, then that requested country would make a judgment to extradite the individual. That would not be the end of that process. That individual in that requested country will have, in the usual way, the right of appeal. In this country, United Kingdom, this will go to the Court of Appeal. If the person is still not happy with the Court of Appeal decision, this will go to our Supreme Court, and which is the final court in the land. And if the Supreme Court makes the decision that the person should be extradited, that is still, again, not the end of the matter. That goes to the politicians, the Prime Minister, the Home Secretary, the Foreign Secretary. The politicians will make a decision as to whether the individual will be handed over to the requesting country or not, despite the judgment of the court. Once the government have made its decision, the individual, again, still has the right to request judicial review of that decision of the state to return them to the requesting country. Again, it starts again back to the High Court, to the Court of Appeal, and to the Supreme Court, depending on the reason and evidence in support of resistance. This process could take years to complete. These are safeguards that are inbuilt in this process to protect anyone facing extradition. There is a case law, which was a case between Regina and Horse Ferry Magistrate, ex parte Bennett. This was a case of one Mr. Paul Bennett, who was a New Zealand citizen who lived in the United Kingdom. In 1992, committed financial offense and fled to South Africa. The British police and the South African police arranged to bring Mr. Paul Bennett back to the United Kingdom without following the extradition procedure. The matter went to the magistrate court, and the magistrate court, from the magistrate court, the matter was appealed as a question to the High Court. The High Court decided that it had no jurisdiction. Then the matter was appealed to the Court of Appeal and all the way to the House of Lords in 1993. The decision was that the High Court has the power to inquire as to how Mr. Paul Bennett was brought back into the United Kingdom to face trial. The result of that judgment was that the trial against the charges against Mr. Bennett and the trial were suspended, and Mr. Bennett was released from prison and returned to South Africa. This case is very similar to Mr. Kanu's case. So, the question for anyone to understand, the question for everyone, and for the court, for the government, is whether the Nigerian government has jurisdiction to try Mr. Kanu, given that the government has not proved or explained how Mr. Kanu was brought back to the country. It is not for Mr. Kanu to prove how he got back into the country. All he needs to do is to explain that he was never in the country and that he didn't know how he got in this country. Then it will be for the government to explain how this person came to be physically facing trial in Nigeria. Without an explanation as to how this person came to be facing trial in Nigeria, no court in Nigeria will have jurisdiction to try Mr. Kanu. That now begs the question, why is he still being detained? Could the government come up with alternative charges against him and bring him to the court? Now, one other thing that we have to understand about extradition, let's now go back to extradition again. If someone makes an application for extradition in another country, and if that extradition is granted, that extradition is only going to be granted for the offenses for which that person is charged. Is there any need for us to talk about that now when we know that there was no such process? Can the court, can the states come up with more charges and again try to circumvent the extradition procedure? Yes, they can. The problem with that is that any such an attempt will be met with an application to the court for abuse of process or res judicata. There is a confusion about what the Court of Appeal might have said about the charges itself. These are not part of, these in my view, are not, I do not think that they are part of what the Court of Appeal was asked to decide. What the Court of Appeal probably was asked to decide was just the question of extradition. And as it would normally happen in most cases, some lawyers would want to seek, maybe the advocate may want to also seek the opinion of the judges on other matters, such as those charges themselves. And these judges may want to comment on them. But they do not form the ratio of the decision that they've made. In legal terms, they're called obiter dicta. The main decision which they made would be the decision that is bordering on extradition, which comes within the ratio decidendi. It is a lot easier to create confusion when someone goes to read the wrong side, the wrong side of the law. Because there will be two sides to that judgment. Read the wrong side, then you cause confusion for yourself. The right side to read is the ratio. However, I must say that the problem with that judgment was the word discharged. Which was the order that was made. And having said that, should have said that Mr. Kanu should be released. With that, and that would have settled the current confusion at this moment in time. Which also would cause this individual to remain in prison for some time longer. And we'll have to now go through all the legal processes, which are very unnecessary. They will now have to be fighting to make an application for abuse of process, fighting to save the judgment that has been made, which they ought not to do. So, in conclusion, the state is wrong to say that that they would not release Mr. Kanu because the judge did not use the word acquittal. The state does not understand the meaning of acquittal. Acquittal happens following a trial. The opposite of acquittal is conviction. And it's only after conviction can someone be sentenced. Just something I didn't mention here. Discharge means that this is how far this matter will go. It shouldn't go any further. That's what discharge means. That it stops here. Doesn't make any move. So having discharged the case against Mr. Kanu, the state still holding him in detention on the basis of those charges would be holding him unlawfully. as I have said and as I quoted the case of Ex parte Bennett, it is not possible for the state to manufacture or to come up with further charges. If there's going to be any charges, they have to let this person go and be a free man. And if they want to arrest him in the future, they probably can do that. If he's not in the country, they can go through extradition process to bring him back. But having made a decision by the Court of Appeal that the matter is discharged, and that is the court order. Thank you.